You're tuned in to Agriculture Today, and we start our Wednesday show reviewing some of the top stories in ag law and tax in 2023. And then to talk about it, we're joined by K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
My pleasure, Shelby.
Roger, talking about just a few of the top stories, which we'll cover more throughout this month. And the first one being labor disputes in agriculture.
Yeah, this is a really important one. Maybe not so much for producers in Kansas, but in other parts of the country, particularly in the fruit and vegetable production arena. But what happened here in this one, Shelby, is that in 23, the U.S. Supreme Court said an employer can sidestep federal administrative agency procedures of the National Labor Relations Board and go straight to court when striking workers damage the company's property rather than just cause economic harm. What you had in this case, it's not an ag case, but it's directly, I think, related to ag because we had a perishable commodity involved. But what you had was a concrete company that filed a lawsuit for damages against the labor union that represented its drivers. What the workers did was fill the mixer trucks with concrete that was ready to pour, knowing they were going to walk away. Well, that's a problem because that is a perishable commodity right there. If that concrete sets up, you can't use it for the job. So the company sued for damage to their property, something that is not protected under federal labor law. And the union said, well, you can't do that. You have to go to federal administrative channels first, the National Labor Relations Board. And the court said, no, this is more like an ordinary tort lawsuit. It's not a federal labor dispute. Company goes straight to court. And the key point was the court said that walking away was inconsistent with accepting a perishable commodity. And there's your tie to ag, because when we have labor disputes in ag, in those parts of ag that are unionized, which is largely in fruits and vegetables, the labor dispute is oftentimes to damage perishable food products like fruit and veggies. So merely timing a work stoppage during harvest, while that might not be enough to be deemed economic damage unless the union has a contract, I think that striking during a sorting line has begun, or after the sorting line has begun, would seem to be enough to say that's economic damage, and you don't have to go through, as the employer, you don't have to go through federal labor administrative procedures.
Something else that made it to court in 2023, a case involving the Swampbuster rules.
Yeah, Swampbuster is the farm program that came in the mid-1980s along with CRP conservation title of the 1985 Farm Bill that says that you can't drain certain defined wet areas and grow crops on them and receive farm subsidies for doing that. So that's known as Swampbuster. We had Southbuster and Swampbuster and CRP and all of that that came in the mid-'80s. Well, what you had in this case in South Dakota was back in 1936, the farmer at issue, his father planted a tree belt to prevent erosion, and that tree belt grew over the years, and it collects deep snow drifts in the winter. In other words, it does its job. The snow piles up close to the tree bank, keeps it off of the roads, keeps it off of the field. But then when the spring comes and the weather warms up, the melting snow collects in a low spot in the middle of the field before soaking into the ground to evaporate. Now, we're talking a very small spot here. This is a fraction of an acre. And in 2011, the USDA called the puddle a wetland, subject to the Swampbuster rules, couldn't farm it, and they refused to reconsider that determination, even though they had a legal obligation to do so by statute, when the farmer presented new evidence that countered the USDA's position. In other words, he came back and said, based on the soil type, based on all your rules, your three conditions for having a wetland that are in your rules, USDA, I've got evidence that shows that it doesn't satisfy those conditions, and it's not. Well, they wouldn't reconsider. So he challenged that determination in court, as well as the USDA's unwillingness to reconsider, and he lost. And I think that's wrong, and this case has been, petition of certiorari has been filed with the U.S. Supreme Court. So we'll see if the U.S. Supreme Court takes this case in 2024.
Thinking about farmers and their land, then, something else important from 2023, railbanking.
Yeah, railbanking it goes back into the 70s, but the primary act on this was in 1983, the Rails to Trails legislation, which says that when a railroad abandons its line, it can go through a process where the line will be converted into a recreational trail. And many listeners probably have seen those trails or have used them to ride bikes on or walk on, but they go through farmland. And the question really is a property law question, is when there's an abandonment by the railroad, what happens to that corridor? Should it revert to the landowners that own the land adjacent along that were subject to the easement that the railroad had. And that really kind of begs the property law question. Did the grant to the railroad originally grant them an easement, which would then revert after it ends to the adjacent landowners, or was it deeded outright to the railroad? And that's a question that depends on the language of the deed. It also depends on state law. But what you had in 2023 was the U.S. Court of Appeals for the Federal Circuit that said that you have a Fifth Amendment taking that occurs in these rail trail situations when a trail is considered outside the scope of the original railway easement. And again, that's going to depend on that language in the original grant to the railroad plus state law. This was a Missouri statute that was involved in this case, and the court said that the railroad grant only allowed the railroad to construct, maintain, and accommodate the line. And so once it was no longer used for a railroad purpose, the easement ceased to exist, and trail use is not a railroad purpose. And so when the ties were removed and the tracks were removed, that showed there'd be no realistic railroad use of the easement, and the trail use was unrelated to operation of the railway. And you had a taking that occurred when that land did not revert back to the farmers along that line.
Thinking about some court rulings that have taken place, confined animal feeding operations, some things happening around those.
Yeah, back in the Obama administration, the second Obama administration, back in 2016, the USDA came up with a rule that exempted what they defined as medium-sized confined animal feeding operations, or CAFOs, from environmental review for FSA loan purposes. And again, a medium-sized CAFO is still pretty big. That's 700 dairy cows, 2,500 55-pound hogs, or 125,000 chickens. And they said, well, we don't think there's any, we don't have to make any environmental analysis. We're not triggering that requirement under the National Environmental Protection Act because the action wouldn't individually or cumulatively have a significant effect on the human environment. And so they said, we can just unilaterally and categorically exempt medium-sized CAFOs from environmental review. Well, there were some farm groups that challenged that, and the court disagreed with the USDA. They vacated the rule. And the interesting thing in this one was the Farm Service Agency, which had the rule, they wrote the rules, conceded that it made no finding as to environmental impact. So they didn't even try to determine whether or not there was any environmental impact. They just said, well, we're not going to make any analysis. We're just going to write the rule and exempt these CAFOs from environmental review. The court said that's a fatal flaw. You have to give public notice in these types of things. When you write a rule, agency, give public notice, open it up for comment before you write your final rule. Now, I don't think this is over. In 2024, I think it's likely that the agency will again try to exempt medium-sized CAFOs from environmental review for FSA loan purposes. So we may not have seen the last of this one.
And our last thing we're going to review today from 2023, Charitable Remainder Annuity Trust Abuse, and a case that went along with that.
Yeah, this is actually, they had a case in 2022 and another one in 2023, and the full tax court opinion came down in 2023, and it involved the same players that were providing really bad and fraudulent tax advice associated with these charitable remainder trusts, and the focus was on farmers. This group that was involved in this, kind of centered in Columbia, Missouri, took out an ad in the High Plains Journal and really said some things that are wrong and questionable in that ad, but it sucked in a lot of farmers. It sucked in over 70 farmers, and the tax deficiencies, we found out later, were about $14, $15 million in deficient tax that should have been paid that wasn't because of the fraudulent nature of these trusts. Now, a charitable remainder annuity trust is not a bad thing in and of itself. It can be a very useful tax planning tool, particularly if you have a retiring farmer who's got that last harvest and they deferred last year's harvest income into this year, and now they have this year's income from their harvest, and they don't want to report 2 years' worth of income in 1 year and then have a bunch of self-employment tax on top of that. Well, we can create a CRAT and get around that corner on this, but if you put your crop into this, like this group in Missouri was advising, they said, well, put your crops in it and you can take a charitable deduction for the value of the crop. Well, no, you can't because you don't have any income tax basis in that raised crop. You've already deducted those expenses out. You can't get a charitable deduction, and all the income coming back to you is going to be ordinary income under that annuity stream. And there were a whole host of things that were wrong in the advice that they gave. And it really messed up numerous farmers' lives in this. Lots of tax deficiencies and penalties and so forth. And fortunately, the IRS Criminal Investigation Division found out about this, investigated, turned it over to the Department of Justice, and the Department of Justice shut these promoters down.
And is this case just another good example of why good tax advice is important?
Good tax advice is always important. Sometimes it's difficult to distinguish the fraudsters from those that are giving good advice. And what I like to tell people is often, if it seems too good to be true, you might want to get a second opinion.
Roger, I appreciate you taking the time to join us today and share with us a few of the top stories from 2023.
My pleasure, Shelby. Thanks for having me.
That was K-State and Washburn Law Professor Roger McEowen. In today's show notes on agtoday.net, I will link his blog article that also talks about these stories.